Today I'm very honored to introduce Professor Chie Ikeya, who's our own Cornell alum, and we have the same advisor in the past. So yeah, I'm very honored to introduce her here. And I'm also very happy to finally have the chance to meet you in person because your work has deeply informed and inspired my PhD research. Yeah, so Professor Chie Ikeya, she has recently become the full professor of history, and she's also the director of the Institute for Research on Women and co-director of the Global Asia's Initiative at Rutgers University, New Brunswick. She's the author of two monographs, Inter-Asian Intimacies Across Race, Religion, and Colonialism, which was published with the Cornell University Press this year, and Refiguring Women, Colonialism, and Modernity in Burma. Today, you can actually get a copy of her new book at a discount rate at the end of this lecture. So if you're interested, please do let us know at the end. Professor Chie Ikeya's talk today is titled The Buddhist Woman's Special Marriage and Succession Act, Laws of Intimacy and Segregation in Transregional Perspective. And we would also like to thank the History Department for kindly co-sponsoring this lecture. So without further ado, let's give a warm welcome to Professor Chie Ikeya.
Thank you so much. Can you hear me? Good. Okay. All right. Well, thank you so much, Xingpeng and Amijan. Thank you so much for that kind introduction. I'd also like to thank the Gatty and Graduate Student Committee for the invitation, and the staff of the Southeast Asian Studies Program, not least Emily Falika, for facilitating my visit. As some of you know, Inter-Asian Intimacies was seeded by my doctoral dissertation, written under the supervision of Tamara Luce, Eric Tagliacozzo, and Anne Blackburn. One of the more surprising and significant revelations of that work was the influence of South-South inter-Asian transits of people and ideas on the making of modern Burma, and just how comprehensively that history had been suppressed by the assumption that the East-West encounter between indigenous people and European colonizers had indelibly defined the emergence of modernity in Southeast Asia and in colonized regions more generally. This realization emboldened me to redirect my attention to understanding more deeply how Asian interactions had shaped Burmese people. My book, Inter-Asian Intimacies, is the result of this conceptual and theoretical shift in my scholarship. The book uncovers a history of belonging across boundaries that has been overshadowed by Eurocentric narratives of métissage, the sexual and cultural mixing of white colonial masters and native mistresses. In the context of Asia, such relations were numerically insignificant, and yet scholars have repeated this tired paradigm of colonial intercourse. Another challenge in exploring the history of inter-Asian intimacies is that such connections have been negatively referenced, both in scholarship and in archives. In scholarship, theories of communalism and the so-called plural society in which people of different races and religions exist as proximate yet separate communities without ever forging a common sense of belonging have dominated interpretations of Asian relations. In archives, they appear as offenses under the law and sources of social ill, moral panic, and political turmoil that require suppression. As I show in the book, in Burma as elsewhere in Southeast Asia, inter-Asian relationships became the locus of political agitation, legislative activism, and collective violence over the course of the 20th century. In the decades leading up to the Second World War, those who self-identified as protectors of the Bodhabada, Bama Myo, or Burmese Buddhist kind, charged others, Myoja in Burmese, with seducing unsuspecting Burmese Buddhist women into fraudulent marriage in involuntary conversions. They imagined the Burmese Buddhist as an exceptional species of just, tolerant people who had no history of sex, caste, racial, and religious discrimination. The Burmese Buddhists were therefore worthy of universal admiration and protection from conversion and miscegenation. A woman who disobeyed this conjugal mandate to marry a Burmese Buddhist was deemed an infidel who had betrayed her own religion, race, and nation. This alarmist imagination of the Burmese Buddhist as an exceptional and endangered community, what I term Burmese Buddhist exceptionalism, authorized attempts by lawmakers, politicians, and religious authorities to consign minority Asians to subordinate status and restrict women's autonomy. Charting the history of inter-Asian relations beyond such negative references of anxieties and apprehensions and disaffections and violence has required me to continually reconsider the possibilities and limitations of archival excavation, family history, and storytelling. The book itself interweaves analysis of archival findings and intergenerational stories of the family of Rosie Nyenyi and Pondicherry Mahanarajan, a family descended from many generations of intermarriage and conversion among Buddhists, Christians, and Muslims, and Arabs, Burmese, and Indians. The photo featured in the cover of the book, featured here, is of Auntie Rosie's parents, Ahmed, Mia, or Umia in Burmese, Helen May de Vries, her sister Cecilia, and Auntie Rosie's eldest sister and brother. Their experiences and memories of migration, intermarriage, and conversion allowed me to not only document the resilience of belonging across boundaries in the face of repeated injunctions and threats of devastation, but also to illuminate the unruly ties and complex subjectivities that constitute reality for so many and yet are so hard to capture in studies. So I hadn't planned on this, but I decided that I would take a moment to briefly share with you some of these family stories, which I have honestly closely guarded until the publication of the book just last month. So what I'm about to read appear in chapter 3 in a subsection titled Belonging Beyond Categories, the New Burmas. Let me see if this works. That's not working. Okay. The idea that Islam was intrinsically alien in Burma would have offended Magali and Ucho, as well as their youngest child, Ahmed, and his wife, Helen May, the eldest daughter of Didi and de Vries. Sometime in the late 1910s, Ahmed had returned from attending the Calcutta Medical College. Magali had expected that upon his return home with a status-enhancing medical degree, Ahmed would help her manage the thriving family business, like his 4 siblings. She had also chosen a suitable Muslim bride, perhaps a Saida, for Ahmed to marry, but Ahmed did neither. He started his own medical practice in Rangoon and eloped with Helen, who worked at his clinic as a nurse. When Helen met Ahmed, she was engaged to her first cousin and fellow Baptist, Freddie. Aware that Magali would not approve their relationship, Helen and Ahmed decided to run off to Mandalay to marry and start a new life. Fatigued from the travel, Ahmed suggested that they disembark at Pyamana, located halfway between Mandalay and Rangoon and situated on the Rangoon-Mandalay main railway line for a brief respite. They never proceeded to Mandalay, marrying in Pyamana instead. This is how Auntie Rosie recounts her parents' marriage. Her eldest daughter, Mona, heard a different story. Ahmed was equivocal about their relationship, not only because Helen was already engaged, but also due to the disparaging views of his friends for whom Helen was not good enough. A ward of orphanages for Eurasians and poor whites, she was beneath someone of Ahmed's pedigree and influence. In his characteristically non-confrontational style, Ahmed ran away to Mandalay rather than break off or commit to his relationship with Helen. In her typically confrontational style, Helen followed him. She kicked open the door to his apartment, grabbed him, and went in search in the middle of the night for a Muslim authority to officiate the marriage ceremony. Helen converted to Islam, and the couple signed a Muslim nuptial contract. In recounting the story to her grandchildren, Helen made one thing clear. She ran off with Ahmed, not the other way around. News of the marriage shocked Mowgli, who disowned Ahmed. Estranged from his family, Ahmed decided not to return to Rangoon. He and Helen settled down in Bumana, a place to which they had no prior connection. Using what was left of his inheritance, Ahmed and Helen established the only medical clinic in town, the New Burma Medical Hall, after which the couple and their children came to be known locally as the New Burmas. So the New Burma clan would grow as Yamuna itself grew, and I detail that in the book, but I'm skipping here a little bit. And Ahmed and Helen had 11 children in quick succession. They're featured here in this photo, which is not part of the book, actually. As is obvious, perhaps, from the names of the children, theirs was a bewilderingly heterogeneous family. Muslims, Christians, and Buddhists, Zebadi, Karens, Burmans, and Eurasians, and Burmese, Urdu, and English speakers all lived together as one unit. Everyone ate halal. The men in the family went to the mosque for Eid, and Ahmed and Helen recited Muslim prayers. The children, however, were not taught Muslim prayers. They learned instead to recite Christian and Buddhist prayers from their Aunt Sissy and the longtime servant affectionately known as Ame Than or Mother Than. The New Burmas were a polyglot family, moving fluidly between different Baba, language, and religion. This versatility in Baba, however, was too much for Helen's liking at times. As the only general medical practitioner in town, Ahmed welcomed visits by traveling Ponjis or Buddhist monks who stopped by his home for medical consultations. These visits, which turned into philosophical ruminations on Buddhist scripture, irritated Helen. I quote, "Why are you talking every day, anesa or impermanence, and doka, suffering?" She would chastise Ahmed. She even complained directly to the Ponjis, letting them know that she had little tolerance for what she perceived, probably correctly, as their attempt to propagate the Bodhabada. Though both Ahmed and Helen were practicing Muslims, Helen was the more devout of the two. She was the only member of the family who observed the daily fast during Ramadan. In her old age, she hired a teacher to instruct her in reciting the Quran in both Arabic and Urdu. She also began covering her head during prayer, though she never wore a veil of any sort in public. Adhering to the doctrinally conservative view that the visitation of graves by women is prohibited by Islam, Helen refused to go to the cemetery where Ahmed and their daughter Jenny were buried. Memories of Helen among her descendants thus paint a portrait of a self-consciously pious Muslim convert, albeit one that does not resemble the stereotypical image of the devout Muslim woman for whom the metonym is the veil. It is a portrait that troubles once again the idea that conversion in the context of intermarriage is purely pragmatic. Like other women converts we encountered in chapter 1, who demonstrated curiosity and conviction in the religion of their spouses, her conversion to Islam was more than just a means to an end. Did Helen feel pressure to model herself after the women in Ahmed's family who, by all accounts, were very religious? In contrast, the Mias have described none of Mowgli's sons as particularly religious. Perhaps Helen wanted to prove to Mowgli, her sister-in-law, or to herself that she was a worthy wife and daughter-in-law, befitting a Sayyid, despite her humble background and her status as a convert. There is no denying that the New Burmas were an extraordinary family. But as the following chapters show, they were neither unusual nor unfamiliar relations in colonial Burma. Rather, they were quite typical of the many marriages and families that straddled administrative categories and legal boundaries, as court records of domestic disputes attest. The prevalence of such personal relations never moved the British administrators to revise their classification schemes or to acknowledge the problems imminent in their strategy of governance. Instead, colonial authorities persisted in enforcing the bureaucratic illogic and illusion of a religiously and racially segregated colonial society, rendering common forms of intimacy and subjectivity illicit. Their insistence on the validity of colonial schemes also entailed the fabrication of another powerful unreality. A Burmese woman who married a foreigner came into the fold of her husband, adopting his religious and legal status, while immigrant men and their locally born sons, even those who were culturally assimilated, retained their own religious and legal personhood. On the basis of this fantasy and alibi, colonial officials rationalized their consolidation of a patriarchal legal regime of alienation. So I'll stop there. The following chapters take up this question of law, gender, and alienation. So in the rest of my talk, I want to move beyond the book to probe the unlikely interconnections in logics and laws of intimacy and segregation across colonial, national, and regional divides. The literature on laws governing intimacy has historically honed in on anti-miscegenation laws in Anglophone, white settler, colonial settings. And while the scholarship on law, colonial modernity, and marriage reforms on Southeast Asia, at least, has provided important insights into the central role that polygamy and monogamy laws played in imperial racial regimes, not least as justification for the racialized legal apartheid between Europeans and Asians, as Go Chuan-Sang argues. The extant literature has focused much less on the regulation of mixed marriage, including interracial, interreligious, and intercaste marriages. By tending to this lacuna, I hope to show that mixed marriage laws have constituted the legal bulwark for the gender segregation of natives versus aliens, and that they have served to segregate Asians as much as Asians and Europeans. In colonial Asia, there were virtually no prohibition laws like the anti-miscegenation laws, which were intended to defend white supremacy and secure the propertied patriarchal rights of white men. Instead, colonial administrations enacted such laws as the Special Marriage Act of 1872 in British India, of which Burma was a province at the time, and the GHR of 1898 in the Dutch East Indies that regulated mixed marriage. Putatively aimed at allowing intermarriage, these laws in fact prevented or restricted the practice by penalizing women in mixed relations. For instance, the Special Marriage Act of 1879 provided for civil marriage before a registrar without religious ceremonies, under the condition that couples marrying under this law declare that they did not, quote, profess the Christian or the Jewish, or the Hindu or the Muslim, or the Parsi or the Buddhist, or the Sikh or the Jaina religion. In addition to this self-excommunication clause, as Nandini Chatterjee has described it, the law stripped women of the benefit of religious laws of marriage and inheritance by subjecting the married couple and their children to the legal jurisdiction of the religious laws of the husband. Foreshadowing metropolitan laws such as the 1914 British Nationality and Status of Aliens Act that deprived British women who married a quote-unquote alien of their British nationality, the Special Marriage Act sought to discourage women from mixing with non-European men by threatening the forfeiture of their and their children's civil status. The GHR of 1898 in the Dutch East Indies similarly subjected the wife to the law of her husband. Due to the restrictive nature of these mixed marriage laws, colonial subjects intermarried without recourse to them. As a result, the civil courts continually ran up against marriages and families that challenged the colonial judicial system of plural legal jurisdiction, which organized subjects into discrete religious and racial communities governable by their respective laws. This meant that in Burma, the civil courts administered the Buddhist law in cases concerning marriage, divorce, adoption, and inheritance when the parties were Buddhist, Hindu law when the parties were Hindu, and so on. Masquerading as immutable reality, colonial governments across Asia implemented a legal system of cordon sanitaire that developed out of a colonial imperative, a simple and stable classification of legal status, to each of which one and only one personal law could be uniformly applied. The colonial civil courts had to answer for the confusion created by this legal system. Namely, what was the status of marriages and births that transgressed religious categories in legal jurisdictions? This judicial uncertainty made intermarriage and mixed births susceptible to two types of interconnected legal challenges: the legality of the marriage and the legitimacy of the births, and the personal law to be used to govern the affairs and property of the individual, spouses, or family in question. To provide but a few examples from British Burma, in 1905, R.K. Mudaliar, alias Maumon, had his right to his father's estate contested by his cousin, W.R. Vanugopal. According to the latter, Maumon was an illegitimate child who descended from two generations of illicit unions between Hindu men and Burmese women. Maumon's maternal grandmother, Thuza, Vanugopal pointed out, was Burmese Buddhist, not Hindu. The legal principle recognized by the British that there was no such thing as Hindu by conversion meant that Magun, Thuza's daughter with her Hindu husband Narayan Swami, Naidu, was neither a legitimate child nor a Hindu. Maumon, the son of Magun and an Orthodox Hindu, was likewise illegitimate and not Hindu. Vanugopal, it would seem, had a watertight case. However, the presiding judges reasoned that Thuza, though Buddhist at the time of her marriage to Narayan Swami, was regarded as Hindu and brought up all her children as Hindus and married them to Hindus according to Hindu rites. The judges declared lawful the marriage between Thuza and Narayan Swami and validated the Hindu status of Thuza, Magun, and Maumon. As this case demonstrates, colonial jurists maneuvered around the question about the status of marriages and births that transgressed religious categories and laws rather than offer straightforward answers. They accepted the conversion of Buddhist women to Hinduism to make way for a lawful Hindu-Buddhist marriage, contravening their own position on the impossibility of Hindu by conversion. Still, there were many cases where the court dismissed outright the legal validity of such relationships. For example, when Chie was sued by her Hindu husband, Ramaswamy, in 1906, the two had lived together for 16 years and had 6 children. But Ramaswamy argued in court that because she was not Hindu, she was not his lawful wife, and he successfully denied her any right to his property. Thuka nearly suffered the same fate as Chie in 1915, when her Chinese husband, who had deserted her and their children, claimed that she was not his wife, but merely a mistress. Somanji had refused to pay maintenance and hoped that declaring Thuka a mistress would relieve him of his financial obligation as husband and father. Fortunately for Thuka, Somanji's own witnesses, including his relatives, recognized the two as man and wife. My examination of these and other civil court cases for inter-Asian intimacies revealed that colonial authorities refused to allow Chinese, Hindu, Muslim, Sino-Burmese, and Indo-Burmese subjects to have recourse to the Burmese Buddhist law. In not one of the over 100 cases that I examined did British judges allow this to happen. It was impossible for subjects with Hindu, Muslim, or Chinese kin to escape their patrilineal personal status through religious conversion or intermarriage. Personal laws were nominally based on religious affiliation, but were practically determined by ties of patrilineal affiliation. In this sense, as Judith Serkis observes in her study of plural legal jurisdiction in French Algeria, religious personal status was jus sanguinis, or right of blood with a religious name, except in the case of the Burmese Buddhist, who could alter their personal status through conversion and intermarriage. British jurists routinely subjected Buddhist women and their property to the personal laws of their non-Buddhist husbands. Put differently, colonial jurists validated mixed marriages only under the same condition required by the Special Marriage Act, that the wife submit to the religion and law of her spouse. This is notable because of the British admiration for Burmese Buddhist law. Many in this audience will be familiar with colonial discourses and representations of Oriental civilizations that authorized colonial rule and rendered colonized women objects of rescue by white men and women. Interestingly, the British took exception with the Burmese. Burmese Buddhist laws, British officials praised, were free of social evils common among other Oriental societies. For example, the judicial commissioner and legal scholar John Jardine, while granting that Burmese Buddhist law recognized the husband as the lord of his household and of his wife, marveled at the Burmese wife's, quote, wonderful facilities for terminating the marriage whenever she so desires, unquote. He rendered incomparable this liberty, unlike patria potestas, or the Roman law of paternal power over daughter and wife. Also writing in the late 19th century, another British officer in Burma proclaimed that in no material points, hardly even in minor points, does the law discriminate against women in Burma. The British administration for Burmese Buddhist law was overwhelming, so much so that they conveniently excused the fact that polygyny remained legal under Burmese Buddhist law by characterizing it as a form of marriage that no longer had social sanction. When British judges had the choice of applying this liberal Burmese Buddhist law to subjects who straddled religious and racial categories, they refused. And when they had the opportunity to apply it as the personal law of Burmese Buddhist women with non-Buddhist or Chinese Buddhist partners, they resisted. In rhetoric, they abhorred what they took to be the subjugation of women under Oriental laws and praised what they regarded as the incomparable independence of Burmese wives. In practice, they refrained from constraining the patriarch's right to put his house in order. They pitted minority rights against indigenous rights along gender lines, as Chinese, Muslim, and Hindu patriarchs' rights against Burmese Buddhist women's rights, to alienate women of their property and personhood. Far from saving brown women from brown men, British imperialists allied with brown men who appealed to the colonial state for immunity from Buddhist law to circumvent the established legal capacity of Burmese women. This patriarchal alliance between British imperialists and their colonial subjects created a legal enclosure that systematically alienated Burmese women. The colonial alibi for this patriarchal consolidation were the Burmese Buddhist women themselves, whom the British jurists characterized as willing agents in their own alienation. Colonial legal experts camouflaged their authorization of patriarchy as the imperial protection of the rights of religious minorities and of women's capacity to consent to intermarriage and conversion. Coincidentally, when the all-male Legislative Council in Burma debated in 1927, and for the first time, a proposal for marriage reform, it was a motion to apply the Dhammatha to marriages between Burmese women and foreigners. Dhammatha are a small group of indigenous legal texts that form the basis of British understanding of Burmese Buddhist law. Pola, the councilman behind the motion, explained the need for the reform. When a woman of Burma marries a foreigner and the marriage is contracted under the Burma Buddhist Dhammatha, the marriage is not valid. The marriage has to be contracted under the laws of their husbands who are foreigners. Because the legislators were themselves lawyers with knowledge of the conflicts internal to the colonial system of personal law, they framed their grievances about intermarriage as a problem of legal disability for the Burmese Buddhist wives and their children. The solution that the Burmese legislators urged was correspondingly legalistic. A more extensive application of Buddhist law that would supersede the personal laws of the foreign spouses. While the proposed solution challenged the judicial edifice of British colonial rule, the justifications for the solution summoned staple Orientalist tropes of marriage and family. Propensity for polygyny and unilateral repudiation or talaq by Muslim husbands, preference for sons among the Chinese, and aversion to polygyny amongst the Burmese. It also reinforced the British characterization of intermarriage as the outmarriage of the Burmese wife and reified the legal fiction that underpinned the colonial legal system, that the subject population in Burma was made up of discrete and irreconcilable religious and racial communities. While mounted in the name of saving Burmese Buddhist women and their rights to family and property, the motion to bring intermarriage into the jurisdiction of Burmese Buddhist law was an attempt to bring marriage, family, and property under the authority of the male-dominated government and to police the sexual and moral conduct of Burmese women. Burmese legislators ascribed to the women who intermarried an incapacity to think for themselves and laid the grounds for denying Burmese women the right to consent to intermarriage and conversion. The legislative debate over the application of Burmese Buddhist law to marriages between Burmese women and foreigners resulted in the drafting of the so-called Buddhist Marriage and Divorce Bill. It was only in 1939 that a bill governing the marriage of Buddhist women in Burma to non-Buddhist men was finally approved. An iteration of the legislative proposal debated in 1927, the Buddhist Women's Special Marriage and Succession Bill mandated that the Burmese Buddhist law apply to all questions relating to the marriage, divorce, inheritance, and the ownership of property of a woman belonging to any of the indigenous races of Burma who profess the Buddhist faith, regardless of the religious status of her spouse. While the 1927 bill authorized the father of or other relatives of the bride to deny their consent for the marriage, the 1939 iteration expanded the authority to contest the marriage to, quote, any person with objections to the marriage, unquote, and not only required the woman seeking to marry a non-Buddhist to file a notice of intent with the registrar 14 days in advance of the marriage, but also instructed the registrar to publicize the intent to marry and notify her family. The Buddhist Women's Special Marriage and Succession Act finally came into force in 1954 after Burma's independence from Britain in 1948. In 2015, the monastic nationalist organization Mabatha, Association to Protect a Nation in Buddhism, successfully campaigned to revise the act as one of 4 laws, euphemistically known as National Race and Religion Protection Laws. Under this law, persons other than the individual who intermarries or converts are permitted to initiate criminal proceedings against a Burmese Buddhist woman and her non-Buddhist partner who cohabit without registering the marriage. The 2015 law preserves the Buddhist woman's freedom to profess the religion freely according to her faith by prohibiting the conversion of Buddhist women by using various means. The vague language leaves open to interpretation what constitutes forced conversion. The law furthermore allows any married woman who is a Myanmar citizen, regardless of her religion, to have recourse to the law through the act of conversion to Buddhism, with the obvious objective of encouraging women to revert to Buddhism. The 1954 Act has been described as an exceptional law, the first and only in Asia to protect the rights specific to Buddhist women. Yet, a close examination of the law and its 2015 iteration reveals important continuities between them and the colonial legal governance of mixed marriage. According to the 2015 law, a Buddhist woman means a woman who is a citizen of the Republic of the Union of Myanmar and a woman who professes the Buddhist faith or born of parents who profess the Buddhist faith. The law does not clarify whether it applies to women of Buddhist families who have converted to another religion. This amendment to the 1954 Act consolidates the logic of segregation immanent in the colonial system of plural legal jurisdiction. Theoretically based on religious affiliation, personal laws are practically determined by ties affiliation. The law therefore restricts the ability of women in Myanmar to escape the jurisdiction of Burmese Buddhist law and extends to Burmese Buddhist women the legal principle that the British jurists covertly applied to anyone but a Burmese Buddhist woman under colonial rule. Religious personal status is right of blood with a religious name. There are also important parallels between the Buddhist women's special marriage law and national marriage laws of countries such as Indonesia, the anti-miscegenation laws of the US, and the anti-conversion laws in India that have been enacted in the name of protecting women and the freedom of religion. Although countries in Southeast Asia have been associated with religious and racial pluralism and female autonomy, they share with white settler colonial nations and nations in the so-called patriarchal belt concerns about mixing and the purity of the ruling group, which they attempt to safeguard by expanding the power of the law to control women's bodies and restrict their capacity to consent to intermarriage and conversion. Intermarriage has proved to be as controversial a legal issue in South and Southeast Asian nations as in nations that have a history of anti-miscegenation laws. It has served as a flashpoint not only for legislative debates, but public demonstrations and violence, such as the 1938 anti-Indian riots in Burma and the Maria Hertog riots of 1950 in Singapore. Marriage between a Muslim and a non-Muslim person and the related process of conversion especially has caused controversy, and not only in Muslim-majority nations like Indonesia and Malaysia, where such a marriage is not allowed, but conversion out of Islam is. In Muslim-majority countries, Christians have been accused of undercover attempts to missionize and convert Muslim women through intermarriage. In Buddhist or Hindu-majority nations like Myanmar and India, Muslims have been accused of love jihad, an alleged conspiracy to forcibly convert unsuspecting women to Islam through rape and duplicitous marriage. Where legislative activism has failed, religious bodies have issued orders forbidding intermarriage and organized Marry Buddhist or Return to Hinduism campaigns. All such campaigns portray women of the majority religion as susceptible to coercion, deception, and seduction by racial and religious others, and therefore in need of custodial care. The fear of violation of presumptively vulnerable women by others and through intermarriage has allowed government and religious authorities in Asia to subject their minoritized populations to violence and to empower the paternalistic supervision of women's religion, sexuality, and property, all under the guise of protecting women. So I'll conclude quickly. An intersectional comparative approach to the study of the governance of intermarriage and miscegenation that considers religion as vital and analytic lens as race reveals conjunctions and connections in the historical articulations of law, religion, race, and gender that have sustained inequalities and enforced hierarchies. Across geographies and chronologies, mixed marriage has constituted a key site and subject of legislative and religious activism and bureaucratic learning. A close examination of intermarriage and conversion laws brings into sharp focus the segregationist and patriarchal tendencies of regions long identified with racial and religious pluralism and female autonomy. Across disparate contexts, marriage laws have functioned to create Asian foreigners as separate races and communities, setting them apart legally and socially. In the name of protecting women, mixed marriage laws have served to protect the purity of the ruling or majority group by empowering state and social control of women's sexual, reproductive, and property rights. The governance of mixed marriage through law is precisely how state and society and institution and people have come to know and care about religion, race, and nation, and what it means to belong or not belong. Thank you so much.